Welcome. Some projects or developments should never have been authorized, and yet despite compromising our natural resources and the well-being of affected communities, they are. So in this video, we explain how you can effectively stand up against this injustice by getting involved during the EIA process and submitting an appeal on a wrongful decision. Then in our second video, that is part 2 for patrons, we explain the next course of action in the case that all this fails. Welcome. My name is Sean McGregor of ecoleges Environmental Consultants based in Mpumalanga, South Africa, and we're on a mission to empower all South Africans to protect their environment through the correct interpretation and application of our environmental legislation. So if you want to learn how our environmental law applies to you, how to avoid costly and unnecessary mistakes, if you want to increase your knowledge and skills to reduce your reliance on external consultants, if you're in need of mentorship or you just want to earn CPD points for a professional registration, then subscribe to this channel. You can do that by swiping your mouse over the icon to the bottom right hand side of your screen, and don't forget to click on the bell notification icon so that you can be notified the moment we upload a new video. If you do know of anyone else who can benefit from these videos, we would really appreciate your support by liking them just to help spread the message. Thank you. The title of this video is How Can I Appeal an Environmental Authorization? Our two sources of information used in this video are the amended EIA regulations of 2014 and the amended National Appeal Regulations of 2014. I'll include a link to both those pieces of legislation in the description below. A person can get involved during the EIA process by registering as an interested and affected party once the Environmental Assessment Practitioner, or EAP, has given notice about the proposed project. The EAP is obligated to give notice by erecting a site notice board at the site where the activity is proposed to be undertaken, by placing an advert in a local newspaper, and if you are the owner, person in control or occupier of the proposed site or land adjacent to the proposed site, then the EAP has to submit a written notice to you as well. You can register at any time, but we do highly recommend that you register as soon as possible so that you are involved in the dissemination of draft reports and specialist studies for public comment. In order to qualify for registration, you will need to either submit comments, attend public meetings, or request in writing to be replaced on the register. You will need to provide your name, contact details, address, and disclose any business, financial, personal, or any other interest that you may have in the approval or refusal of the application. The EAP then has to respond to those comments, even if it's only in the report, and submit both the comments and his or her response to the competent authority. Then once the competent authority has reached a decision on the application, it is possible to appeal either the granting or refusal of an environmental authorization. However, the appeal process will need to be aligned with the requirements of the amended National Appeal Regulations of 2014. Firstly, the applicant or EAP has to notify all registered interested and affected parties of the decision within 14 days of the date of the decision on the application. Then the appellant has 20 days from the date of the notice to submit an appeal to the appeal administrator, as well as, and this is important, sending a copy to the applicant, any registered interested and affected party with an interest in the matter, and any organ of state with an interest in the matter. The appeal has to be submitted in writing on an official form that is obtainable from the appeal administrator and must be accompanied by a statement setting out the grounds for the appeal, any supporting documents that are referenced in that statement, as well as another statement including supporting documents to confirm that a copy of the appeal was sent to the applicant, any registered interested and affected party, and any organ of state that has an interest in the matter. The applicant, decision maker, registered interested and affected party, and organ of state then has 20 days from the date of receipt of the appeal submission to submit a responding statement. The appeal administrator then has 30 days from receiving the responding statements to make a recommendation on the appeal to the appeal authority, and that is provided no independent expert advice was sought, or provided that an appeal panel did not have to be constituted. The appeal authority must then reach a decision and notify the appellant, applicant, registered interest affected party, and any organ of state with an interest in the matter within 20 days of the recommendation on the appeal by the appeal administrator. That notification must include reasons for the decision. Then finally, any documents like the appeal submission can be hand-delivered, sent by registered mail, faxed, emailed, or posted by ordinary mail. Please just remember, if you do decide to send it by registered mail or ordinary post, those documents will also need to be backed up or sent by email, fax, or hand-delivered in order to stick to these strict time frames or time periods. And that's it. I really hope this has been helpful, and thank you so much for taking the time to watch it. If you have joined our membership program, then you will receive an additional video. We explain the next course of action or recourse in the case of the competent authority not adhering to those time periods prescribed in the National Appeal Regulations, or if they fail to sufficiently substantiate their reasons for taking a decision on an appeal submission. If you haven't joined our membership program yet, then check it out on Patreon. Otherwise, if you're looking for a consultant to help you with a once-off project, you are welcome to visit our website. Check out our previous video. We explain or provide some clarity on existing lawful use as an authorization for Section 21 water uses. Next video, just as important, don't miss it. Ladies and gentlemen, subscribe, click on the bell notification icon. If you know of anyone else who can benefit from these videos, please like them. Otherwise, thank you, keep strong, and God bless.